The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw an eye and give their attention to the court. Now sitting.
Please be seated. Good morning. Welcome to the 9 a.m. docket for the Supreme Court today. We're very pleased to have a couple of visiting groups with us this morning. Professor Mulligan, would you mind coming forward and introducing your group?
Please the court. Thank you, Chief Justice, and the members of the court. I'm here today with 29 undergraduate students from University of Kansas, Wichita State, and Kansas State, who are part of our statewide LEAD program, which allows exceptional high school students to enter a 6-year as opposed to 7-year program. They earn their BA in 3 and then go directly into law school. So these are really motivated, very smart, hardworking young people, and we're excited to be here today. Thank you.
Thank you. Welcome to all of you. We are excited about not only your presence, but your participation in the LEAD program. We think it's an amazing process. So hopefully we'll have a chance to visit with all of you, not only today, but at future times as well. And Professor Watson?
I am so happy to be here. It's been 3 years since we've had a Washburn class to come in, and so we're so excited. I have undergrad also, intro to law class, and my students are also exceptional. They're very excited to be here and to see the court in action in person. And we actually also have 2 international students, one from Paraguay and one from Belgium. So they're comparing how their courts look and the system works to ours. So thank you so much for having us today.
Thank you, and welcome to all the students. As you probably know, you have a great person to explain all of that to you. I had the privilege of Professor Watson working in my chambers for several years, so I think very highly of her and appreciate her. So with that, we'll move forward then with our docket. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the morning docket.
Thank you, Honor. The first case on the 9 a.m. docket for Monday, October 24th, 2022 is appeal number 123684, Nancy Granados et al. Versus John Wilson and Key Insurance Company, Wyandotte County. This case is set for 20-minute argument, both sides. Briefs have been filed on both sides.
May it please the court. Mike Blanton on behalf of Nancy Granados, the appellee and cross appellant in this matter, present and ready for argument.
May it please the court, James P. Maloney for the appellant and cross appellee, Key Insurance Company, present and ready for argument.
Thank you, counsel.
Second case is appeal number 125417 in the matter of Troy J. Leavitt, original action and attorney discipline, no briefs filed.
Kathleen Selzler-Lippert, Deputy Disciplinary Administrator on behalf of the Disciplinary Administrator's Office, present and ready for argument. I would request 3 minutes for rebuttal.
May it please the court. Peggy Wilson appears on behalf of respondent Troy Leavitt. Mr. Leavitt also personally appears. We are present and ready for argument.
Your Honor, that concludes the 9 a.m. docket.
Thank you, Mr. Shima. Counsel want to come forward, please, in 123684. And while you do so, I will just explain to the audience, I think parties know this, that Justice Dan Biles has recused from hearing this first case on the morning docket. That means that he will not participate in the oral argument, nor will he participate in the court conferencing the case or in the court making its decision. I also want to explain to those who are visiting or watching us on our YouTube channel that generally the court is very familiar with the facts of the case, and the arguments that the parties have presented to us. We come to the oral argument having read the briefs, portions or most of the record, not all, and having had a research memo prepared to us internally by our research staff. We do look forward to the arguments and the exchange that we will have with counsel as we explore the arguments that they make. You'll notice that there will be times we will be looking at our computers. And we do that to consult the personal notes that we have taken, to double check something that might be in a brief or in a case, to look at something in the record. All of these things are done not to distract us from the argument, but to really assist us in understanding and processing the argument as they're presented to us. So we just wanted to assure you that when we're doing that, we are listening very closely to the parties' arguments and are very engaged in that. With that, a little bit of introduction, and I'll talk a little bit more about the process as we proceed through the morning. I will call 1, 2, 3, 6, 8, 4 and ask counsel to please come forward for the argument. Mr. Blanton.
And Your Honor, I forgot to request if I could have 5 minutes for rebuttal,
5
please.
minutes of rebuttal, certainly.
Thank you. May it please the court. Mike Blanton on behalf of Nancy Granados. Parties in this case agree on at least one thing, and that's that the primary issue before this court is causation. And that's because both the district court and the Court of Appeals have already held that Key breached its duties to its insured. But the Court of Appeals held that because plaintiff rejected a post-suit settlement offer, the causal chain was broken. So there are two key questions presented to this court. First, after a tortfeasor tells his insurance company about an accident, is the insurance company allowed to disregard its duties to its insured unless and until the injured party submits a demand? And second, can an insurance company cure its pre-suit violations of its duties to its insured by making post-suit settlement offers and claiming that if the plaintiff rejects those post-suit offers, then the causal chain is broken? Now, the primary focus in this case is causation, but it's still important to consider when the insurance company's duties arise. And it's important, particularly in this case, because both Key and the amicus briefing party, Kansas Association of Defense Counsel, have argued that an insurance company owes no duties to its insured unless and until it receives a demand from the injured party. Key said in its brief, liability for bad faith is imposed for breach of an insurance company's duty to defend, which does not arise and cannot be breached unless and until a claim or action to defend has been asserted. And KADC similarly took the position that an insurance company has no duties until it receives a demand from the injured party. Now, the assertion that there are no duties until there's a demand from an injured party is not the rule in Kansas. And if this court were to adopt that rule, we would suggest that it should at least carve out an exception for a situation like we have in this case, where the injured party didn't even know the insurance company existed prior to the time she filed suit.
Counsel, can I interrupt you for a second?
Yes,
Let me back up and when we talk about the duty of an insurer under Kansas law, really, aren't we talking about essentially just two duties, duty to act with ordinary care and in good faith? And then whether or not an insurer's conduct under a given set of circumstances is a breach of either of those two duties, then is really a factually driven question. Would you agree with that premise that the legal question in terms of the duty, there are two, whether there is a breach of that duty depends on the circumstances? Let me just start there with that premise.
One qualifier at the beginning, I do agree the two broad duties are good faith and to act with due care. The courts have also recognized that the duty of good faith encompasses 4 separate duties: to investigate, evaluate, communicate, and pursue settlement. Is in any case where you're talking about duty and breach, duty is a legal issue and breach is a factual issue. And again, in this case, both the district court and the Court of Appeals have already concluded that the evidence supported the conclusion that Key breached its duties, both its duty to investigate and its duty to communicate. So that's why I say, I don't believe duty is the issue here. I believe it's causation, because that was expressly the basis of the Court of Appeals ruling.
Right, but in terms of the question of when the duty commenced or arose, is that settled law in Kansas already? That once a claim has been filed where in excess of policy limits, that haven't we already in Shroop and also the federal courts interpreting our case law have said that's sort of the trigger?
Once the insurance company is on notice.
Once a claim is filed that where damages exceed policy limits.
I would say once the insurance company is notified of the incident giving rise to the claim. There's been a lot of dispute in this case about what is a claim. He seems to take the position that there's no claim until somebody comes forward and formally asserts, if not saying I'm, at the basis saying I'm asserting a claim. But it's a little more ambiguous than that because he's never clear about it. He has said, well, we don't have to have a demand before our duties arise. We just need to have a claim, but they're never clear on what they mean by that. Now, in their brief, in their most recent brief, they said, well, we need notice that, let me find the right page, excuse me, Your Honor. He said, we need notice that the person has an interest in pursuing a claim, or that the person has an interest in recovery for their injuries. But the reality is that that has no basis under Kansas law. That Kansas courts haven't said that a party has to come forward first and say, I'm the injured party and I would like to be compensated for my injuries. Frankly, I think that kind of goes without saying. In almost every case, the injured party wants to be compensated for their injuries. I won't say it's impossible that there's somebody out there who says, I was injured, but I have no interest in being compensated, but that would be the rare exception. So for Key to say, Key acts like until somebody comes forward and says, I want to be compensated for my injuries, we have no idea whether the injured party will want to be compensated for their injuries. Actually, I think the real question isn't whether they'll want to be compensated. The real question is, will they sue the insured? And that's why the insurance company needs to start acting as soon as it receives notice. Because once it receives notice, it knows that its insured is at risk at that point, and it can't simply sit back and do nothing until it hears from the injured party.
And it doesn't matter who provides that notice. In other words, does our case law or any of our statutory provisions distinguish between whether that notice comes from the insured or from the third party claimant?
The case law doesn't distinguish. The case law simply indicates that when the insurer has notice of the claim, and again, our position would be, and it comes back to this dispute about claim. When we say claim, our position is that's a legal claim. And a claim arises as soon as the injury occurs under Kansas law. That's when we talk about a statute of limitations, the statute runs from the time that the injury occurs. We say there's a claim and you have 2 years to file a suit on your claim. And so under similar analysis, there's a claim as soon as the injury occurs. And as soon as the insurer receives notice, regardless of who they receive that notice from, they have notice of a claim. And although Key keeps arguing that it didn't have a claim in this case, I would respectfully suggest that's disingenuous. Key received notice from its insured the day after the accident occurred, that the accident occurred and that a death had resulted from that accident. Key opened a claim file at that time, and Key recognizes that that's all that's necessary to start a claim in its system is receiving notice from its insured. As the corporate representative, Leonard Graxon, stated, it doesn't require someone to have come forward and asserted anything. So Mr. Graxon acknowledged, all we need is notice from our insured to open a claim. But more than that, on November 22nd, 2017, about a month and a half after the accident, he identified plaintiff, my client, as the claimant on that file. So by November 22nd, Key had a claim and it knew who the claimant was. And Key also knew at that point that the police report in the case did not identify Key. And Key's representatives acknowledged at trial, that means plaintiff would have no way of knowing that Key existed, because when she looked at the police report, it didn't show that Mr. Wilson was insured. And Key's own policies required it to reach out to contact the claimant. Key's policies regarding investigation said, when you take a new loss, the very first thing you do when you put down the phone is call everyone involved, call the insured, claimant, witnesses. And Key's policies require Key's adjusters to aggressively pursue claimants, insureds, and witnesses. So if Key had followed its own policies here and reached out to the claimant who it had identified as the claimant in its own file, Nancy Granados testified at trial, and the district court indicated it believed this testimony. She testified that if she had heard from an insurance company before she filed suit, she would have settled for policy limits. So if Key had simply followed its own policies in this case, it would have reached out to the claimant shortly after the accident by late November, once it had identified the claimant. And once it reached out to Mrs. Granados, she would have accepted the policy limits and we wouldn't be here today.
Mr. Blanton, to that end, if you could clarify some facts in the record for me, in the chronology. There was a letter sent to your client that was dated May 31st, 2018 from State Farm, her own insurance agent. And it stated that Nancy had a liability claim against Key Insurance and an underinsured claim against the State Farm policy. Now, in the briefs, it kind of seems like maybe she didn't open that letter, I don't know, until June 9th. But from your version of fact, are there any facts in the record to show when she opened that letter?
Not the precise date, but the evidence in the record does establish that she didn't open the letter until after she had filed suit. She'd been out of the country.
And could you give me a record site for that?
I will, when I'm
Okay,
closing counsel is arguing, I will find that it's cited in both the briefs, or at least in the original underlying briefs. And the appellate, the district court again recognized and found that.
so there's a
that
finding
Nancy
of fact that she did not open that envelope that was dated May 31st until after June 12th.
I don't know that the district court states it that precisely in its order. That was certainly the evidence presented to the court and the evidence that the district court relied upon in issuing its ruling. I think it's been undisputed. There's no evidence in this case that she had that letter before she filed suit. And again, the standard of review in this case, I believe the court should be looking at the evidence in a light that would support the underlying verdict. And the evidence in this case was that she did not have that letter, or she had not seen that letter before she filed suit, and she wasn't aware that Key existed. That was the evidence presented on behalf of plaintiff, and I believe the court should take the evidence in that light for purposes of reviewing the district court's ruling in this case.
When we're talking about the factual findings of the district court, let me ask you one more. Let's just presume that a duty to act with ordinary care existed sometime after November of 17, when Key did their liability analysis and concluded that their insured was liable and damages would exceed policy limits. Doesn't the district court make a finding that even assuming a duty existed to act with ordinary care, it wasn't breached in this case because the injured party had made no overtures or demand of Key or the insured? And there's testimony in the record that 2/3 of these kind of cases never materialize into any sort of claim. And therefore, the district court concluded it was just good business judgment not to initiate settlement at that juncture.
So 2 points. One, the district court did hold, it had actually held in a prior summary judgment ruling that the duty to settle had not arisen, but the district court expressly found that the duties to investigate and communicate were breached. So the court absolutely found there were breaches of duties. And in the underlying trial, he did try to suggest that it was a strategy not to contact Nancy Granados, that they thought it was better to hold back and wait and see. But the testimony of the claims adjuster and the corporate rep completely undermined that. Mr. Gregg.
Let's focus on what the district court, because there's disputed evidence. The district court said and concluded that it was sound business judgment. And that finding appears to me to be supported by the testimony from the claims adjuster, her name escapes me, Soto or something, that, 2/3 of these types of situations never materialize in a claim, and we haven't heard anything from the plaintiff. So it was sound business judgment to just write it out. So
I don't think, there was certainly evidence presented on both sides of the question. I don't recall the court saying that in its order in this case. Again, the judgment actually on settlement had been in the underlying summary judgment. And so at trial, the issue of settlement wasn't actually before the court because the court had already ruled on that. At the trial, the evidence presented, and again, Key was trying to pursue this theory of, well, this was strategy on our part. You know, we were purposely not reaching out to Ms. Granados, but the corporate representative, Mr. Graxon, specifically said that he couldn't point to a single entry in the claim file that showed there was a conscious strategy not to reach out to Mrs. Granados. And the claim rep said it wasn't a conscious strategy that she undertook in the best interest of the insured. It was just something that happened. So although Key tried to make it sound like we were being very wise and sitting back and not contacting Mrs. Granados, the testimony of the representatives of the insurance company made it clear there was no grand strategy. There was just incompetence. There was a failure to properly investigate and a failure to communicate. One other point I wanted to try and reach briefly here. The core argument of Key is that it was Nancy Granados' rejection of the post-suit settlement offer that broke the causal chain in this case. So in essence, what they're arguing is that that was an intervening cause. That when Nancy Granados, after the Key had already been in bad faith and negligent, when Nancy Granados then rejected the post-suit settlement offer, that broke the causal chain. That's not the law in Kansas, though, because Kansas courts have repeatedly recognized that if a subsequent action is foreseeable, then it's not an intervening cause. It's only an intervening cause if it was unforeseeable. And it was very foreseeable that when Key made a post-suit settlement offer, that post-suit settlement offer would be rejected. Indeed, the law at that point, and we believe still the law in Kansas, is that an insurance company cannot cure its prior negligence and bad faith by offering the policy limits after suit has been filed.
Let me ask you one more question. The duty here is failure. There was a duty to investigate and communicate, which was breached, right?
Yes, Your Honor.
Okay. The duty to investigate included contacting your client, Nancy, and I guess the other witnesses, et cetera, right?
Yes, Your Honor.
And communicate, I guess that would be part of the investigation, including their own client.
It's mainly
insured.
communicating with their own client, which
Right.
they did not do at all for 8 months.
Okay, and what did that cause, this failure to investigate and communicate?
So with respect to the failure to investigate,
Huh.
if Key had followed its own policies and had reached out to the claimant once it knew the claimant existed, Nancy Granados testified in this case, and the district court did expressly indicate it believed her, that if an insurance company had reached out to her before she filed suit, she would have settled for policy limits. So if Key had followed its own policy and contacted the claimant, that would have allowed the claimant to know that there was an insurance company there because she didn't know before then, and the matter would have been settled for policy limits before suit was ever filed. So there was causation in that instance. With respect to communication, it's very important that an insurer communicate with its own insured so that its insured understands the risk. In this case, Key didn't communicate with its insured at all for 8 months after he initially notified them of the accident. So Mr. Wilson, as far as he knows, he was doing everything it should be doing to protect him. But as the corporate representative, Mr. Graxon, recognized, if you haven't communicated with your insured, it's impossible to know what the insured would feel about the possible.
But they did
excess
ultimately
exposure.
protect him
I beg your
they
pardon?
did ultimately protect him, right?
I don't believe they did under Kansas law because.
Didn't they
after
say,
suit-
if you don't sue him for the excess amount, we'll give you $25,000?
After suit was filed,
Right.
they did offer the policy limits, and Kansas law expressly provides that they cannot escape their prior bad faith and negligence by offering policy
Right,
limits.
but they
after
protected
suit
their
is filed.
insured so that he would not be liable for anything above the $25,000 that they offered, right?
Not when it was rejected, no. At that point, the insured, Mr. Wilson, was subject to exposure for the excess judgment. The fact that the insurer.
Right, but at the end of the
offers-
day, he wasn't, right?
Because of the Glenn agreement, yeah, at the end of the day pursuant to an agreement, but it was only because of an agreement with plaintiff that the insured was protected. It wasn't because of what the insurance company.
Well, who paid the $25,000?
They paid the 25,000.
Hey,
The insurance company
Thank
Key
you.
paid the limit, but the fact that the insurance company
understand.
pays the limit doesn't automatically protect its insurance from an
Counsel.
excess judgment.
I'm going to jump in quick
Sure.
because I know you're out of time, but real quick, you mentioned from the transcript, the testimony, that it would have been impossible to know what the insured would have done had there been communication. Is that correct? I think
That's
that's what you
correct.
read from the testimony.
Correct.
So my question is, was there ever any evidence in the record that would have answered that question? In other words, that seems to me to be an evidentiary hole in the case. Do we actually know from evidence what the insured would have done had he been communicated with?
Well, first of all, I think the natural assumption.
Well, no,
is-
my question is
I-
there evidence in the record, not about assumptions or speculation?
We know that once Mr. Wilson was sued and Mr. Wilson provided that complaint to his insurer, the insurer, as your honor noted, then did offer the policy limits. While it's not expressly stated, I assume Key did that with its own client's permission or direction. So we do know that Mr. Wilson would have wanted the policy limits. to
So
be
if
provided.
reading between the lines, your answer to my question is no, there is no evidence in the record, no direct evidence that tells us what, in other words, the insured didn't testify. There's no direct evidence saying if I had been communicated with pre-suit, I would have done X, Y, Z.
There's no evidence of any communications with the insurer because the insurer did not communicate. And it's important to note,
Well, sure.
the insured, Mr. Wilson, died during trial. So we weren't able to call Mr. Wilson as a rebuttal witness, and the record establishes he wasn't available.
And there could have been other ways to establish what he would have done had he been communicated with.
Frankly, when Key presented the argument at trial that we don't know if our own insured would have wanted us to try and protect him by offering policy limits, that was surprising to us because we would think all insureds would want their insured to protect them by offering policy limits. So, but we did not have the opportunity to call Mr. Wilson as a rebuttal witness with respect to that argument by Key.
But isn't there case law that says that conflict of interest, if you will, doesn't arise until a claim is made?
Well, again, I think it doesn't arise until the insurer is notified of the existence of a claim. And under Kansas law, there's a claim when the injury occurs. That's how we treat claims under Kansas law. That's what we measure the statute from. The insurance company was notified the day after the accident that the accident had occurred and that there had been a fatality in that accident. By December 19th, Key Insurance had
Isn't
determined.
that really for purposes of determining what the damages are? The damages start at the time of the accident and then going forward to determine what was caused, what damage was caused by this accident. But it's circular to say that when the claim actually was triggered, when we know that somebody is going to want money for the injuries. And before that, maybe they were friends. Maybe the claimant didn't, for some reason, want to get whatever it was that the insured had. Or maybe there were many potential claimants who might make claims and might not make claims. So how is the insurance company to know that there actually is going to be a claim made?
I think it's important to flip that around respectfully, Your Honor. Ask yourself, Key's position is until somebody submits some type of formal demand or claim to us, we have no duties. So that would mean they don't have to investigate. They don't have to do anything. They could just sit back and do absolutely nothing until they hear from an injured party. Looking at the Kansas cases, I don't believe that's the message that this court wants to send to insurance companies, that until you receive a formal demand from an injured party, you're free to do absolutely nothing to protect your insured. I think the duty to investigate arises right at the beginning. As soon as they know of the incident, it's important to start investigating. A record gets stale. And so if they don't have duties to investigate until they hear from an injured party, that doesn't support that duty. They need to evaluate. They need to communicate with their own insured. So I think it's entirely inconsistent with Kansas law to say an insurance company has no duties at all until it hears from an injured party, even though its own client has contacted it. I think it's important to look at this from the insured's perspective. I'm insured and I'm in an accident and I contact my insurance company the next day. I then don't hear from my insurance. And why do I contact them? Because I want them to protect me. That's why I reach out to my insurance company. I then don't hear from them for 8 months. Naturally, I'm assuming they must be doing what they should be doing to protect me during those 8 months because I've not heard anything else from them. But then 8 months later, I'm sued and I go to my insurance company. If my insurance company were to say to me at that point, oh, we're sorry, we had no responsibility to do anything at all until we heard from the injured party, I think I would be shocked as an insured to learn that that was the case.
Well, but they did, the evidence shows they did investigate it. After it was reported, he said, I don't really know what happened. I'd been drinking and it was investigated by the insurance company to a degree.
They obtained a copy of the police report. That was the full extent of their investigation. They never contacted a single witness, client, anybody. All they did was obtain a copy of the police report.
Which showed that their insured had rear-ended another person.
It was
Right.
enough for them to determine that their insured was at fault, and they knew because it was a death case that the damages were far in excess of policy limits. And even then, they failed to communicate with their insured and say, there's huge exposure here, and bring their insured into the loop in making those decisions. In fact, the claims adjuster testified that they didn't contact the insured to just let the insured weigh in on how they wanted to proceed with whether they should pursue settlement or not. Instead, he made that decision for him. So he decided, we're just going to sit back for 8 months and wait and see if you get sued. And then if you get sued, then we'll try to offer the policy limits to make it go away, but we're not going to do anything to protect you.
But there was another claim made that they did pay policy limits for.
They did pay the policy limits, but again, this is the nature of bad faith cases. I mean, in bad faith cases, the Kansas law has clearly held that a party pursuant to the Glenn decision, that the insured can enter into an agreement after suit is filed in order to protect itself. And that was done here. There's nothing improper about that. That happens all the time. But the longstanding rule in Kansas is that an insurance company can't cure its own prior bad faith and negligence by making a post-suit settlement offer. If an insurer could do that, that's a get out of jail card. I mean, that basically tells the insurer, you don't have to worry about anything. If you hear from your insured that they were in an accident, you can just sit back and do nothing at all until you hear
Counsel,
from the injured party.
Let's
Yes, sir.
assume that the communication that you say ought to have happened had happened. Why wouldn't it be reasonable for the insured to say, thanks for letting me know that I have exposure, but I really would rather not have a paid out claim on my policy. So let's just wait and see if a claim's actually made.
And if that had happened, then I think he would have a much better argument.
But isn't
because
that,
it-
you would agree that that would be a reasonable position for an insured to take? Because there's impact on policy premiums and all those kinds of things. And if that's a reasonable position for an insured to take, wasn't there some evidentiary obligation on you in this case to provide evidence that that wouldn't have happened?
I think that's an unlikely position, frankly. I think if he had come to their insured in this case and said, you could be exposed to a potential judgment for millions of dollars, or we could go ahead and offer your $25,000 limits now and protect you. I think the vast majority of insureds would say, yes,
But that's
please
just
protect me.
speculation. We're forced to speculate as to what that would have, as to what would have actually happened.
Frankly, I mean, again, he keeps relying upon the fact we didn't communicate with our own insured, and so we don't know what he would have wanted. Basically, Key's trying to rely on its own incompetence as a defense. I don't think Key should be allowed to rely upon its own complete failure to communicate with its insured.
Well, the insured made an agreement with your client, correct? After that allows you to bring this action.
That is correct.
And
Your Honor.
in the making of that agreement, there could have been you could have seen that this was an evidentiary hole in the case and gotten affidavits. It could have been put down in writing what he would have done.
I mean-
why didn't that happen?
Well, frankly, Your Honor, because Kansas law provides that an insurer cannot cure its negligence and bad faith by making a post-suit settlement offer, we assumed that the law meant exactly what it said. That was the law in place at the time we tried our case. That's the law we were following at the time we tried our case. If this court is going to change that rule and say, well, not always.
Well,
you
counsel,
know,
it's not a question of curing. It's a question of whether liability attaches at all because of causation.
Well, You could certainly look at it that way. I mean, the cases have repeatedly referred to it as curing. There are numerous cases that say an insurer cannot cure its prior bad faith and negligence. In terms of causation, again, if the argument is when at the moment plaintiff rejected the post-suit settlement offer, that broke the causal chain, then that's a matter of intervening cause. And intervening cause can only be in play if it was unforeseeable. So Key would have to be able to say, we never dreamed that somebody would reject our post-suit settlement offer. I think in reality, that's one of the only two options. When an insurance company makes a post-suit settlement offer, it'll either be accepted or rejected. There's only two options, and it was very foreseeable that it would be rejected. So I don't think that's an intervening cause
Yeah,
that can break
I
the
guess
causal chain.
Not to go back and forth too much, but I think the argument is that if the insured had done what I described and said, let's just wait, then there is no breach of any duty for the insured, because the insured has been given the opportunity to make a pre-suit settlement offer and has said, no, I want to wait.
If Key had complied with its duties and communicated with its own insured in this case, and its insured had told Key, once the insured was communicated with, I don't want you to make a settlement offer right now, then clearly that factual situation, which is not in this case, would have provided a defense for Key, but that's not what happened in this case, Your Honor. If there are no other questions at the moment, I will look forward to my rebuttal.
Thank you. Maloney?
James Maloney for Key Insurance Company. May it please the court. I think it's telling that not today, not in any of the briefing, and that's the briefing before the district court, briefing before the Court of Appeals, and the briefing before this court, has there been any authority, case law or otherwise, cited from anywhere in this country that says that an insurance company's duty of good faith or its duty to initiate settlement negotiations starts before a claim has ever been made.
Counsel, let me just start right there. Did Wilson make a claim? I'm looking at your policy, the Keys policy of insurance under reporting a claim. It says, if you, being the insured or any person seeking coverage, is involved in an accident or a loss, here's what you need to do. And it's essentially, you call us, you give us your name and your address, the date of the accident, your vehicle's location, boom. That happened here, right?
Oh, yes, he reported the accident.
Okay, so then the legal question then is, does it matter who reports the claim in this case? Does it have to be the claimant or can it be the insured? And I want to understand if you're arguing that it has to be the injured third party, what is the rationale behind that? Because it seems to me that regardless of who reports the claim, that triggered Keys' claim review and investigation. They concluded we've got a claim here that is going to exceed policy limits. And that seems to implicate the conflict of interest that gives rise to these legal duties.
Yes, Your Honor. I think, first of all, I would agree it does not matter who reports the accident. I would agree it does not matter who reports a claim, but we cannot conflate an accident with a claim. An accident happens and somebody might be injured. That does not.
But I'm reading, I'm sorry, I don't mean to cut you off, but isn't what I was reading to you comes from reporting a claim heading of Keys policy.
It may very well.
Okay. So please, I'm sorry, I didn't mean to cut you off. So let me let you answer the question.
In this case, Mr. Wilson, he did not have a claim. It was only Ms. Granados who could assert her claim. And while Mr. Wilson reported the accident the day after it occurred, he could not report a claim made by Ms. Granados until she actually made that claim. And she did not do that until she filed suit. There's been talk today from counsel for the appellee suggesting that maybe the claim was made before she filed suit. I would point out to this court that there was a finding, either explicit or expressed by the district court, that the claim was not made until Ms. Granados filed suit, which is what led to the determination by the district court that the duty to offer a settlement had not arisen.
Why didn't your client ever ask its insured, hey, what do you want us to do here? We've determined that you've got a big liability.
Your Honor,
What do you want us to do?
Your Honor, I think the testimony was as Mr. Blanton said, that the testimony was that just happened. So I think that's the best we've got in the evidence. in this
What do you
case.
mean that just happened?
That the adjuster testified that was just something that happened. I don't think there was an explanation of.
In other words, it was a
why.
mistake.
Maybe it was.
Okay, so if it was a mistake, are you conceding that that was a breach of a duty to your client? I mean, your client is Key, but to Key's client, to the insured.
I think I would phrase it this way. The district court found that there was that breach, and we have not appealed, saying that finding is not supported by
And
the
it would be an
evidence.
odd thing for an insurance company to take the position that, hey, we don't have to talk to our own customers, right? Just as a general matter.
That's right, Your Honor, but
So if that's the case, I'm going to drill into the same kind of area that I was asking your opposing counsel about. We have this unknown because it didn't happen. What would the insured have done had that communication taken place? What's your position on that question?
I don't have any idea what the insured would have said or done because the insured did not testify.
Do you think that that's a factual question that can be resolved by circumstantial evidence?
I don't think it is because these situations are personal to each individual involved. A claim like this against one person might be different from a claim like this against someone else.
And am I correct in thinking that Key's position as to what evidence is actually in this record is that there's no evidence one way or the other? It's just, and it's a black hole.
That's correct, Your Honor, and that would bring me back to the burden of proof, which is not Key's, it's the plaintiff's burden to prove causation. And if we have no idea what might have happened had there been additional communication with Mr. Wilson, then that's just a matter of the plaintiff failing to prove causation.
And that's our standard of review, correct? That there has to be substantial competent evidence to support the district court's finding that the failure or the breach of the duty to communicate with the insured actually caused the excess judgment.
That's
Right.
correct.
Okay, but what the panel did was a little bit different. They sort of went with this, as your opposing counsel characterized it, as an intervening cause. But causation's a question of fact, right?
That's right.
And our review is substantial competent evidence review. So did the panel apply the right standard of review?
I think the panel did because the panel of the Court of Appeals did not only talk about the causal chain being broken by the rejection by Ms. Granados. The panel also discussed in its opinion this evidentiary hole in the case that we don't know what Mr. Wilson might have said because he was not called to testify at trial. And when there's a comment that he was unavailable, I would point out he was not subpoenaed for trial, nor was his testimony preserved prior to trial through deposition or otherwise. But again, the Court of Appeals talked about both of those issues as pertains to causation.
Right, and I kind of see them as two separate issues because one is doing a substantial competent evidence review and the argument that there's just no evidence to support causation or the finding of the district court. The other led them to a conclusion, though, that, well, I guess essentially that the plaintiff was the cause of the excess judgment. Right, I mean, I guess that's their conclusion, and I'm wondering how you get to that kind of a conclusion without reweighing evidence.
I think the court did discuss that to a great extent in its opinion. Ultimately, though, as I read the Court of Appeals opinion is that they say, we've discussed this, we've talked about this. In the end, we don't have to find that Ms. Granados had some intent of manufacturing a bad faith claim. We don't have to get that far because the question is whether the causation finding from the district court is supported by substantial competent evidence, and it was not. So they discuss it and then essentially say, we're not going to say one way or the other what her intentions or motivations were, but we don't need to decide this case.
Why is not the offer of policy limit circumstantial evidence of Mr. Wilson's intent?
Because frankly, Your Honor, I don't think one thing has anything to do with the other because under the insurance contract, the insurance company can offer that $25,000 with or without the consent of Mr. Wilson. So it does not necessarily reflect that there was some conversation where he said, yes, I do want you to make this offer.
And so why do we have an evidentiary hole? why aren't we back to, why didn't Keys offer the policy limits pre-suit?
Because
Just to protect their insured.
because the only causal connection found by the district court was with a breach of the duty to communicate adequately with Mr. Wilson. That was the only causal connection found. So when there's no evidence to support that finding of causation with regard to those communications, that's the finding that should be reversed. As to
Is the
making,
lack of ability to prove it enough to present a new damage? I mean, this is that odd situation where the breach of the duty leaves the hole, creates a hole. Why is it a claimant's responsibility to cure the breach of duty by Keys?
I don't think it is their duty to cure a breach on Key's part, but it is their burden of proof. And just like at trial, the plaintiff was called and testified and said, if things had happened differently, this is what I would have done. Mr. Wilson could have been called and asked the question, if Key had called you and said X, Y, or Z, what would you have said? What would you have done? What would you have requested be done?
But all the coulda, woulda, shoulda start with Keys, don't they? I mean, isn't that where the duty lay in the duty that was breached? What's the damage from that? I guess is the question. Is the damage that flows from that the potential of an inability to prove to close this evidentiary gap?
Your Honor, there was no inability to close the evidentiary gap because Mr. Wilson could have testified. He could have been called by the plaintiff to testify. And so it's not an inability to prove, it's just that it was not proven.
Well, just that we don't know what he would have done pre-suit, and even if he had been called to testify, wouldn't we have been, we still wouldn't have a contemporaneous statement of him because Keys had not asked pre-suit, what is it you want us to do?
Right, and I would compare that to also not having a contemporaneous statement from Ms. Granados prior to when she filed this suit that she would have been willing to settle for the $25,000 policy limit. But the difference is the plaintiff called herself to testify at trial. Plaintiff did not call Mr. Wilson in order to satisfy the plaintiff's burden of proof as to what might have been different had Key done what they alleged we were supposed to do.
Can I,
Right.
just real quick, I want to clarify something and inquire of Justice Stiegels. And that was the first contact with Wilson the day after or whenever it was that he had a conversation with your client. And the question that Justice Stiegel asked was, that seems to be absent from Key, is what do you want to do? And did I hear you say that never happened with Key and Mr. Wilson?
I think the evidence is that there was never a time when the Key adjuster talked to Mr. Wilson and asked, what do you want to do here?
And so if that's true, why, and given your position in this case, what incentivizes or even requires an insurance adjuster to ask that question? If what occurs happens according to your position, what incentivizes or what requires an adjuster to make that? It just seems to me that's for the position of your position is that that's going to be the standard now. You don't need to ask that question.
You know, Your Honor, I don't think there's something that requires that question to be asked. I can envision circumstances where it would be appropriate to go to the insured, such as if there's multiple claimants, for example, who would, all of their claims hypothetically are worth more than the policy limits, and you're going to settle some but not others. That might be a situation where you need to do that. But that was not necessary here for Key to make its determination once a claim was made that it was going to offer its policy limit.
I wanted to drill down a little bit on what sort of evidence is required to establish causation from breach of duty to communicate with your insured to excess judgment. And we've talked a little bit about testimony from the insured, but I'm wondering, does that even matter when contractually Key controls the right to settle and and they decide whether to settle and when and how to run that defense. Does that mean we really are limited to either somebody from Key testifying or another expert witness to testify that, ordinary care would have required a reasonable insurer or insurance company to make a settlement under these circumstances?
Well, I think that.
In other words, when you control the defense contractually, does it even matter what the testimony of the insured is in terms of establishing causation?
I certainly think it is if the way you're trying to show that a duty was breached and caused damage in the form of a lack of settlement and therefore an excess judgment. If you're trying to show that that's traceable to the insurer's conduct, then yes, absolutely. I guess that would go back to a point that's made in some of the briefs about whether this duty to investigate and this duty to perform a proper evaluation and a duty to communicate with the insured, whether those are actionable on their own, whether those are separate duties, or as your honor's comments earlier today suggested, maybe they're just factors as part of this one, or call it two duties of ordinary care and good faith. And if you look at the Bollinger case, I think you can see these things we're talking about listed as factors from Bollinger versus Nuss, the duty to investigate and communicate with the insured, which our position would be, those are not separate actionable legal duties. And so what we get to is really a question of, did the duty arise before a claim was made? And if not, then we don't even get to that. But if the theory here is that we're going to treat a failure to communicate as actionable duty that Key owed, there has to be some sort of evidence that shows that that failure to communicate led to the excess judgment and the lack of settlement. I don't know what that would be because we did not hear from Mr. Wilson about what he might have said, but we just don't know that because that testimony was not provided.
Counsel, we know that there was $50,000 worth of policy limits and $25,000 per person. So what if there had been three people involved? The first one had a fractured knee from the accident. The second had a fractured hip from the accident. And then there's Nancy Granados, who's on vacation. Fractured knee made a claim before she got back. The fractured hip made a claim before she got back. The money, if they paid it, which both clearly would exceed $25,000, there's nothing left by the time Nancy gets back. So is under the theory that you don't look at each claim as it's made, then wouldn't Key be responsible for all of it anyway by the time she came back?
Your Honor, I don't know that you can say that Key would be responsible for all of it anyway, but that's why I highlight that type of scenario as this is when you do need to talk to your insured, because I can see the conversation between insurance company and insured in this hypothetical being, there's two claims against you. They're both probably worth your policy limit and we could settle them both, but that would leave this other claim pending. We don't know if she's going to make the claim or not, but it could come down the road sometime. We just don't know. And have a conversation with the insured about that and what their risk appetite might be, for example. Ultimately, I do think it's the insurer's decision, but they can have that conversation with the insured.
So it's not based on when the claim is made. It's based on what your knowledge as Key Insurance Company knows about the potential claimants?
Well, in that hypothetical, Your Honor, if I understood correctly, we're talking about a situation where two claims have been made and together they would exhaust the policy limit. So yes, at that point, there have been claims. So they are talking to the insured about those claims and whether to settle those claims.
I'd like to ask,
I'm sorry, so the duty only arises if you know that there are more claims than what have been made?
I think the duty to initiate settlement negotiations doesn't arise until there's a claim that has been made. So for example, when Mr. Elkins, the passenger in Mr. Wilson's car, when he presented a claim, he didn't have to file a lawsuit or jump through any technical hoops. He paid its policy limits and got a release from Mr. Wilson. On the other hand, it was radio silence from Ms. Granados for 8 months for whatever reason. When she filed suit, which was the first indication that she was asserting a claim, Key promptly offered its policy limits in exchange for release of Mr. Wilson. So yes, the duty does arise when there is a claim that has been made, as this court has found in the Sloan case, and as other courts have applied Sloan to their facts.
Does it make any sense to you to use suit being filed as a demarcation upon which the law changes or the duties change?
No, and Key's position is not that the only way to make a claim is to file suit. I think if there had been any sort of indication that Ms. Granados was asserting a claim, that would trigger the duty. So, and that could be as simple as a letter of representation.
I think
from-
I'm asking maybe I asked it poorly, kind of a bigger question. I mean, embedded in this area of the law, it seems to me, is the notion that we want pre-lawsuit settlements to occur, and that insurance companies have some kind of a duty to their insureds because their insureds don't want to get sued. And there's some sort of maybe even unstated, but a presumption that once suit gets filed, the risk of a judgment in excess of limits like just goes through the roof. So it's just like, as soon as that suit hits the courthouse desk, all of a sudden there's this new sort of obligation to protect against these excess limit judgments. But doesn't that risk exist prior to suit also? In other words, I'm struggling with understanding why offering policy limits prior to suit being filed is any different from offering to pay policy limits after suit's been filed. Why is there a difference?
I don't think there is, Your Honor.
But the law treats them differently.
Well, if that's a reference to the law that says you can't cure bad faith that occurred earlier with a post-suit.
I think that it's, again, this notion is embedded in this entire area of the law, that somehow an insurance company that waits to offer policy limits until after suit is filed, that's in a different legal standing vis-a-vis their own insured as an insurance company that offers to pay prior to suit being filed.
Yeah, I don't think it should make a difference. Where that law comes from is the Sloan case, once again. And that issue was considered in the context of a claim for attorney's fees under 40-256. And part of that analysis was that the reason fees should be awarded is because suit was made necessary only by the refusal of not a claim, but in that case, it was actually a demand made to settle.
Right. And so this is court-made law. This is common law in our case law that is clearly incentivizing pre-suit settlements. And I guess my question is, should that be a consideration when we're analyzing contractual and tort duties between an insured and an insurance company?
I certainly think that can be a consideration, Your Honor. I think the law is clear that settlements are favored over litigation. And I think that's a reason why in this case, if there had been some claim made, and we've seen from the testimony and then what actually happened once suit was filed, if there was a claim made prior to suit, in all likelihood, unless it was just going to be rejected by Ms. Granados at that point, which is not the evidence, case would have settled without suit being filed.
So that tells me that you're willing to concede that when an insurance company accepts premiums to provide coverage, part of that coverage, so to speak, is beyond the policy limits. Part of what you're covering your clients, your insureds for, is not to have to go through getting sued. In other words, that's an added, we recognize in the law that that's an added damage beyond just dollars that a person can suffer. And that you as the insurance company have an obligation contractually to protect them against that, if you can.
I'm not sure that I've seen law that says that the filing of suit is additional
No,
damage.
I'm trying to put it in sort of just common English, like what's actually going on in the law here.
Mhm.
That's what I'm trying to understand.
If the question is, does there have to be a lawsuit before an insurance company can make an offer? No, but there shouldn't be a claim before
Well,
they're
let me,
required to
let
make.
me just try to say, ask the question one more time. Do do you agree or disagree that when an insurance company accepts premiums to provide a service, and that service is generally understood to be, we're going to pay money on your behalf up to a certain limit, that in addition to that, you're also taking on a duty to protect your client, the insured, from unnecessary lawsuits?
I think that's probably fair,
Okay.
Your Honor.
Do you think it could be strategic then for a plaintiff claimant to say, okay, on this day, I know who the insurance company is. It's Key Insurance Company. Well before the statute of limitations on a personal injury lawsuit runs. Okay, I know today. Shall I send a letter asking for policy limits, or shall I file a lawsuit that asks for excess judgment? Is the plaintiff's position, the claimant's position, astronomically better if they decide to file a lawsuit instead of sending a letter?
Your Honor, I think so. The question was originally phrased as, could it be strategic? I think absolutely, because the reason that a plaintiff might file a lawsuit instead of sending a letter is for exactly what the Court of Appeals talked about in its opinion, and it's manufacturing a bad faith claim. And what the letter could resolve the case. The letter could result in, okay, Key Insurance Company now sees that a claim is being made. They offer their limit. Ms. Granados is either going to say yes or no.
Is there any reason a smart claimant wouldn't file a lawsuit the day after the accident then?
I'm not sure that I see a reason why that would be problematic in any way.
Think the claimant is better off if they do?
I think that would probably depend on the circumstances, Your Honor.
I'm going to ask you the same question I asked your colleague, which is there any evidence in the record that this letter dated May 31st from State Farm stating Nancy had a liability claim against Key Insurance when she saw that letter?
Your Honor, my recollection from trial and from reviewing the transcript since then is that Ms. Granados testified that when that letter would have arrived, she was on vacation, and that she would have seen it when she got back from that vacation, but that she was not able to pinpoint a date that she actually saw or reviewed that letter.
So she didn't testify when she got back from vacation.
If she did, I don't recall that, but I don't believe there was any sort of date tied to exactly when she read the letter from State Farm.
Did she testify whether she was back from her vacation when suit was filed on June 12th?
I don't recall whether that question was asked at trial, Your Honor.
Other questions?
Thank you.
Martin?
Going to the last question that was asked, my understanding is, one, there's no evidence in the record regarding when the State Farm letter was sent, and there's no evidence in the record regarding when the State Farm letter was received at Nancy Granados' residence. Mrs. Granados did testify at trial multiple times that she did not have the letter and had not seen the letter before she filed her lawsuit in this action. That's at volume 43 of the record, pages 278 and 292 through 294. So she testified multiple times she had not seen that letter before she filed her lawsuit. I don't know the exact date she received it.
What volume? I'm sorry.
Volume 43, Your Honor.
Thank you.
There was a question asking about the insurance contract, and I think that's an important point to emphasize. The insurance contract for Mr. Wilson in this case required the insured to provide notice to the insured of the insurance company of an incident. There is no requirement under the contract that a third party come forward. And again, Representative Leonard Graxon, the corporate rep, stated that when they get a notice of an accident, they open their claim file. He said it doesn't require someone to have come forth and asserted anything. So I think they did have the notice from the insured. Now, one issue in this case, excuse me, Your Honor. We've had some discussion about a lot of discussion about the activity that the injured party took in this case, but I think it's important to note Kansas cases have repeatedly recognized, and this is in the Gruber case I'm quoting, the insurer has to begin settlement negotiations regardless of the actions of the injured party. In Smith v. Blackwell, another case cited in the briefs, the court made that exact same point. So the insurer's duty to start the settlement process doesn't depend on the actions of the injured party.
Where does that duty come from?
The duty to pursue settlement, I think it goes to, as was discussed during questions to opposing counsel, the whole nature of insurance. When a party buys insurance, they're expecting their insurance company to protect
Yeah,
them.
and
that protection includes, I'm sorry, Your Honor, I didn't
No, that's
interrupt.
okay. Go ahead.
And that protection includes not only paying the settlement limits, but taking action timely to help them avoid an excess judgment. The whole underlying premise, as I see it, of the bad faith law is that we want to encourage insurers to do a good job and to follow their duties before their insured is ever sued. That's why we make insurers liable for an excess judgment. It's the incentive to act properly before suit is filed. So if we turn around and say that as long as you offer your policy limits once your client is sued and the plaintiff rejects that, then you're off the hook for all your bad conduct anyway. That completely undoes the underlying premise of bad faith law in
It
Kansas.
seems to me that case law comes out of circumstances where an insurance company unreasonably refuses to settle prior to a lawsuit being filed. In other words, there's communication going back and forth, and the insurance company's just like, no, forget it, I'm not settling. And then this lawsuit happens, and all of a sudden, the claimant has now had to incur a great deal more expense to get a claim paid that should have been paid a long time ago. And so that's really what we're talking about when we talk about protecting against excess judgment. It's this added expense that claimants have to go through to force insurance companies to pay when they should have been paying all along. And that seems to me to be a different circumstance from what we have here, where there wasn't that sort of, and here we're talking about bad faith, right? There wasn't that sort of discussion amongst the parties prior to the lawsuit, and the insurance companies just being recalcitrant.
Well, it's certainly a common scenario that an insurance company will just flat out refuse to offer its limits. That's certainly not the only scenario. There are instances where an insurance company does communicate, but they don't offer their limits before suit is filed. One reference was made earlier to the fact that, well, what if the claimant filed, immediately after the accident? Well, that's where you get into the manufacturing bad faith cases, because in those cases, the scenario that you would repeatedly see was somebody filing suit before the insurer had an opportunity to investigate, but that's not the case here.
But
I mean,
a letter could have been sent here, right?
to Key,
The key from the claimant from Granados.
at the time Mrs. Granados filed suit, she didn't even know Key existed. So she couldn't have sent, she even went out of her way to get the police report to check for insurance, and the police report did not identify any insurance.
Why not
company
just
for
take
Mr.
the money
Wilson.
then when it was offered?
Because again, the law at that point was
Because the thought was, hey, we've got a much bigger claim against this insurance company.
Well, the
because of
reality
way
is,
this happened.
I think it's important, the money she recovered was simply her actual damages. And the law in Kansas is after you filed suit, if the insurer is engaged in bad faith, then you're entitled to
Right, so
require
that's
actual
what,
damages.
that's exactly what I'm asking. There is a contradiction at the heart of your case, which is, hey, we would have been happy to take this money prior to we filed a lawsuit, but somehow when that lawsuit hit the courthouse desk, everything changed. And we didn't, there's not actually facts here that we had to engage in. We had to incur a whole lot of extra expenses and so on. It's just, now that we've filed the lawsuit, we've got this insurance company over the barrel, and we're going to continue to pursue this so we can have this big excess judgment claim.
And going back to your earlier question, While certainly being sure claimants are compensated as part of the underlying policy, I think actually the underlying policy of bad faith law is to encourage insurance companies to act properly to protect their client from being sued in the first place. I think that's precisely why we have that rule, that once your client has been sued, you can't cure your bad faith and negligence by then offering the limits post-suit.
Have I properly surmised why the plaintiff did not accept settlement?
One reason is because she was following the laws that existed at that time. And the other reason is that she incurred attorney's fees after a claim was filed. And as the Gruber Court recognized, that's also an appropriate change of circumstances that can justify a change in position of a plaintiff. The Gruber case was just last year, and the court recognized that was an appropriate basis.
And is the district court, as I recall, the district court actually, the plaintiff had testified that she, would have accepted it. She explained the economic dynamics as to why things changed post-settlement. District court found her testimony credible and made its finding based on that credibility determination. Is that correct?
The district court did. The district court expressly found that she was credible and it believed that testimony, that she would have accepted the policy limits if they've been offered before she filed suit. And again, pursuant to the standard of review, I think this court should accept the district court's finding. The district court was in a better position to assess the credibility of the witness who testified from the stand and accepted her testimony in that regard.
How much time elapsed between the accident and the time suit was filed?
There was 8 months between the time the accident and the time suit was filed. And I would note that plaintiff didn't even retain an attorney for 4 months. She was, as most of us would be if we just lost her spouse, a wreck. Her life was chaos. And the insurance company had already decided 2 months in that its client was at fault and that the damages were far in excess. If Key had simply offered the limits once it reached those determinations before Mrs. Granados even had an attorney, again, she's testified repeatedly, she would have accepted those limits. If I could just have 30 seconds to wrap up, Your Honor. Yes. I think this court can send 2 possible messages to the insurance industry. It can tell insurance companies that they should act in an insured's interest by promptly investigating and evaluating after they receive notice of an incident that gives rise to injuries, maintaining communication with their insured, and attempting to settle before suit is filed so that they protect their insured. Or this court can send the message that upon receiving notice of an incident that caused the death, an insurance company doesn't have to do anything. It should, matter of fact, the safest thing for the insurance company to do is just do nothing. It's not even involved until it hears directly from the injured party. I don't think that's the message this court should be sending to the insurance industry. And I don't think it's consistent with the duties this court has long recognized of insurance companies. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement. There's a way of additional explanation. By that, I mean that the court will now conference the case, after which a justice will be assigned to draft a decision. That will then be reviewed by the justices participating in the case, and that ongoing discussion will continue until a final decision is reached by the court. The decision will then be issued and filed on our website at kscourts.org, and a news release will be issued, so you'll be able to read the opinion reached by the court. Thank you. I will now call 125417 in the matter of Troy J. Leavitt, respondent. Felder Leavitt.
Justice Luker, members of the court, I would request to reserve 3 minutes for rebuttal.
3 minutes reserved. And if you could please restate your appearance just for the clarity of the recording. Thank you.
May it please the court, Kathleen Seltzer-Lippert, Deputy Disciplinary Administrator on behalf of petitioner. Office of the Disciplinary Administrator, present and ready for argument. Case before the court today is an original action for attorney discipline, and the parties have submitted a summary submission that we are requesting this court to consider and adopt. This case originally comes from or stems from reciprocal discipline from the state of Missouri. The state of Missouri alleged or charged that the respondent had violated professional rules of conduct in a Missouri case. The respondent cooperated with the Missouri disciplinary case. He took responsibility for his conduct, entered into stipulations in the Missouri case. He refunded the client fees, and he also paid opposing counsel fees that were imposed. Based on the stipulation, the Missouri Supreme Court in March of 21 suspended the respondent's license for 1 year, stayed that suspension, and placed the respondent on probation. The Kansas Disciplinary Administrator's Office was then advised of the Missouri discipline. In the Missouri case, or the Missouri Supreme Court found that the respondent violated Missouri Supreme Court Rule 1.3, diligence, by failing to exercise the required level of diligence when he failed to promptly respond to a motion to dismiss and failed to file a response or an opposition to attorney's fees. Likewise, the respondent in this case, in the stipulation, stipulated to violating Kansas rules of professional conduct, 1.3 diligence. In the Missouri case, the Missouri Supreme Court found that the respondent violated Rule 1.4 communication by failing to adequately and promptly communicate the status of the case and the judge's adverse ruling in the critical time period of November to December of 2018. Likewise, in the Kansas stipulation, he stipulated that he violated Kansas rules of professional conduct, 1.4 communication, same factual support. In the Missouri case, the respondent stipulated that he violated Rule 8.1 by his comments to his client, calling or describing the judge as rogue or making a rogue decision based on the order of dismissal. In the Missouri case, likewise, the respondent stipulated in Kansas to violating Rule 8.2 for describing to the client that the judge was rogue and that statement was made with either false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of the judge. The Missouri case also noted that he had previously been disciplined in Missouri in 2017. Missouri issued an informal admonition for violation of Rule 1.15 and 1.16. The respondent failed to report that Missouri informal admonition to Kansas, and he stipulated in the summary submission that he violated, or that failure to report violated 8.3 and at that time 2017 Rule 207, which is the duty to report misconduct. Based on the stipulations and the underlying facts, the parties submit or request this court to impose discipline of 12-month suspension, stayed, placing the respondent on probation, which was attached or incorporated as part of the record. And that would be the parties' request. Questions?
Please re-enter your appearance for clarity of the record. Before you begin, thank you.
May it please the court. Peggy Wilson appears on behalf of respondent Troy Leavitt. Mr. Leavitt is also personally appearing, and if allowed, would like to also address the court. What Ms. Lippert said is true. Mr. Leavitt has agreed to the summary submission of this case. The facts of the case are chronologically laid out in our summary submission. And let me discuss with Mr. Leavitt has anger issues. In this one case, In January of 2018, Mr. Leavitt was hired to file a modification, motion for modification on a parenting plan. It was in Jackson County, Missouri, in front of Honorable Margene Burnett. And during this period, opposing counsel, the mother, has filed a motion to dismiss, indicating that there were a discrepancy in the pleadings and needed to file an amended parenting plan, and based on his clients not appearing for case management or counseling issues. Mr. Leavitt believed that amending the parenting plan would render that motion moot, that would have accomplished the whole goal of the whole matter. He also did not want to admit that his client had not appeared at the case management conference or also at the counseling session. But assuming that amending the parenting plan would render it moot, he and opposing counsel went ahead and started scheduling depositions. But the court found that in not opposing the motion to dismiss, the case was dismissed. A judgment was entered, and then the mother, through counsel, filed an application for attorney's fees. Mr. Leavitt had not told his client what was going on at the time. Instead, he tried to fix it by filing a motion to reconsider, which was denied, and the mother was awarded her attorney's fees. Well, you'll see in the record, Mr. Leavitt was personally outraged. He panicked, he was frantic, and he was angry. And he needed to contact his client. So he calls his client. Client's girlfriend answers. Available. In the meantime, my client's just out, just to say the least, because this case has been dismissed and he's very upset. So they have a transition between the client and girlfriend. They have phone calls and texts, and profanity goes on, and that basically disrespectful statements. It indicates that Mr. Leavitt blames the client instead of himself. He failed to mention that he had mistakenly failed to respond to the motion to dismiss, indicated that the judge was rogue in her ruling, and admits he's been at fault. But through Missouri probation plan, Mr. Leavitt has sought treatment for anger management. And believe me, it's worked. It's helped him it's in his practice now. It's helped him in his family issues. His anger management, dealing with problems is resolving. He uses it. He had said, he's here to talk about it when working his clients' anger issues, because he works in family law. He agrees that staying on probation or being on probation in Kansas will continually assist him. He will work. We filed an affidavit on Friday of him being in compliance with probation that we've got planned, and actually Missouri probation too. I apologize for it being late under Rule 227. Generally, in an evidentiary hearing, we're supposed to have that filed 2 weeks ahead in a summary submission. And I thought once it was submitted, we're ready to go. And when talking with counsel last week, we're like, oh my gosh, I think it's implied we need an affidavit. Hope the court still considers it. My apologies for not having it 2 weeks ahead if 227 will applies. But Mr. Leavitt has admitted his fault. He had performed restitution. He sent a letter to the judge apologizing for his comments. They were Missouri I think described them as discriminatory and equated it with the discriminatory action in the prior case with racial discrimination, when this is apologized to her in writing. He apologized to his client in writing. He paid the attorney's fees that were paid by his client, He paid the opposing counsel's fees that were awarded. He has done everything possible to fix it correctly instead of just trying to get it fixed without anybody knowing. So we are here, Your Honors, to ask, respectfully request that the court accept the submission agreement, the summary submission agreement, and place Mr. Leavitt on probation. So his counseling still will work. I may introduce you to Mr. Leavitt. Leavitt, the court.
Morning, Your Honor. In this matter, I'm incredibly embarrassed. I had a situation where I just felt that answering this motion would have been detrimental to my client. That we were better off by not following an answer and by doing. To demonstrate to the court that we are proceeding as followed. We had about 3 months before trial would even begin. When I received the order, I was surprised. Jackson County does have a rule. It just was never really enforced. I was kind of the first person to have it enforced against. No other attorney I talked to had ever had it happen. I felt personally. I took it personally.
Counselor, can you remind me what that rule was?
You have to file a parenting plan with your pleadings. But in this case, it's a little bit different, and this is where this is where I really messed up, was that we had case management, judge didn't like our pleadings, wanted us to change our pleadings and file a parenting plan. The client refused, and I couldn't get him to do it. And so it never got filed, and I had forgotten about it. And so with the motion came around, now he's gonna, I got him in to file the parenting plan. We submit the parenting plan. Hey, I think this is gonna be moot now. We got 3 months. There's really no prejudice to the other side. I think we're okay. And when I got that, I was kind of frustrated. Took about 8 days to respond to him. Should have responded to him much sooner. But I was kind of in my own head. And that's where my anger issues kind of come into play, is that I really should have thought of more, is that not really against me. It was just, this is what the judge had requested for me to do. At that point in time, I call him. I get 6 phone calls from girlfriend, being intoxicated and saying weird things. And then in the last call, I can hear him laughing in the background. And so I just let off a barrage of comments that I shouldn't have let off. I understand, especially now, going through this and the pillars of professionalism as an attorney, we don't have that luxury. I know I'm a solo practitioner. Hey, if you don't want to hire me, don't want to hire me. If this is someone that gets out in the community, but I am representing the bar. I represent this profession, and it's a privilege to be an attorney. And I don't have that right to act my clients in that way. And what I also really have learned through anger management, which I'm really surprised is that how beneficial it's been all around, is that even when my clients come in and talk to me in domestic cases, people want to come in like, oh, I hear you're a bulldog, or I'm like, hey, that's not what we do here. That's what we do here is we're here to wear the white hat. Is that we're here to show that we have the ability to co-parent with the other side. Is that we don't initiate. We have to, and if they do attack us, I don't want you to retaliate. I want you to say, hey, thank you, that you, the other side, I call it, they give you a log. And that's a log for our bonfire. And one of the biggest bonfire wins is the courts want to see that you two can be co-workers and you got one job to raise these beautiful children, and that you have the ability to demonstrate to the court, hey, I'm going to be a and so through what I've learned, like with the anger management, is just not to respond. It's harder than you think sometimes, but not responding would have been the appropriate action in this matter. And I'll use it a lot in my practice and with my client. Also build a better rapport with my clientele, I think also. I think practice is still flourishing and they see I care and I think they feel safer. I can kind of have a big personality. It kind of brought me down a little bit, more humble and listen a lot more than I talk. That's right now, but appreciate your consideration.
Honors, also if on probation, Mr. Levitt's been working with Mr. Riley, David Riley, who he now, as a solo practitioner, he has someone to rely on and to consult with, and it helped in his practice too.
Counselor Lippert?
Unless there are questions, I will yield my time.
Ahmed, do you agree we kind of have a hole in our new summary submission rule that makes it unclear whether the affidavit should be filed? Or-
The summary submission rule is new. It has, while it was implemented originally in January 1st of 2021, I think there was an adjustment or a modification made, I want to say December 30th of 21. I might be off on my exact date there, which clarified that aggravating mitigating information should also be included. And I don't know if it would be a matter of interpretation, whether or not other rules relating to attorney discipline, such as Rule 227 probation, are automatically incorporated when summary submission route or path is utilized. I think that's a fair interpretation. In reviewing Rule 223 summary submission, it doesn't specifically say that 227 should be complied with, but I think that's a fair interpretation. But it is a new rule, and so I don't have any, I don't have a specific reference to fall back on.
And do you have any objection to us considering Mr. Levitt's affidavit?
No.
Thank you. Thank you to everyone for your statements and arguments today. We will take this appeal under advisement as well. The court will now be in recess for 15 minutes.